Welcome to the antitrust law section of the American Bar Association's Hot Tub Debate. Is consumer welfare in hot water? Here's your moderator and host, Bill Kovacic.
Welcome to the Hot Tub. Today we're going to talk about a fundamental question that runs throughout the field of competition law, and that is, what is the purpose of this endeavor, of an area that joins us together in the application of a public policy regime that goes back to the late 19th century? There are obvious answers to what brings us to the field. There are matters of material need and interest. Many of us rely on this in part to earn a living. But I think the interest that draws us together is much broader than that. I think there is a special attraction in the field of competition law that deals with its larger sense of social purpose and its fundamental importance to the operation of a market economy. And it's the definition of that purpose that is a matter of intense contemporary concern. If we go back to the mid-1940s with Learned Hand's epic poem of competition law in Alcoa, you see a broad egalitarian vision of what the law is supposed to accomplish. If you come back to just 60 years ago to Brown-Shue, an interpretation of the US merger regime, you see again a very decisive expression of a broad concept of egalitarian aims and goals. And then further forward to the late 1970s, where that vision disappears from American jurisprudence, and we see the recognition under the umbrella of a phrase called consumer welfare of a microeconomic policy, economic welfare-based conception of competition law that arguably has anchored law and policy for the subsequent period of time. And indeed, into the early 2000s, we see US and EU policy officials, the Commissioner of Competition in the European Union, the heads of the US antitrust agencies, embracing the vision of the consumer interest under the rubric of consumer welfare as being the reason for what we do. And for those of you who've been on an interstellar voyage for the past 5 years and have just come back to the Earth, you'll notice that those assumptions are a matter of extremely vigorous debate today, where we're going back to first principles and asking, what's the point of it all? What are we trying to do? Today, we're going to come in on that topic. There have been many debates on this, and a large number of the debates, in my eye, often start with a high-level discussion of consumer welfare. To mention the phrase causes people to raise the shields right away. The discussion quickly dissolves into what I'd say is a not terribly informative discussion of aims and purpose. We want to come at this a bit different today by drawing in experts who've thought about this, written about it, tried to do it in practice. And our technique today is to take specific case studies as a way of starting out the discussion of what we're trying to do in this field. To talk about the famous US Topco decision of 1972, to talk to a less noted but important decision in the European Union dealing with washing machines and the control of negative environmental externalities, and to use that more specific discussion of individual cases as a way to get into broader themes. And to do this, we have a wonderful ensemble of participants: Sandeep Faheezan from the Open Markets Institute, Tommaso Valetti, Imperial College London, Carl Shapiro, University of California, Berkeley, Diana Moss, American Antitrust Institute, Maureen Olhausen, Baker and Botts, and Dennis Carlton, the University of Chicago. What do they have as a group? I think everybody on this list has written about the topic of the purposes of the antitrust law and their implementation. They have spoken extensively about the subject. They have advised a variety of institutions and enterprises on competition policy cases, and most on this list have actually gone and done it. They've seen theory meet practice. They've crossed the the great distance between the broad idea and its realization in practice. And so their views are in many ways leavened by that experience of not just watching the match, but playing it as well, to see theory meet practice. And the way we're going to go about this is in the spirit of our program, the hot tub. This is innovation inspired by experience in Australia, where experts, instead of testifying seriatim, would be joined up in a discussion supervised by the court of their views, where they'd get to have a genuine conversation. And it's our aim to have that kind of conversation today. We're going to go about it in three parts. We're going to start by talking about TOPCO. We're then going to move to a discussion of the CECED decision involving washing machines in the European Union. And then we're going to come back from that and ask about the continuing utility of the consumer welfare framework and discuss whether or not we need a reformulation of the restatement of the goals and purposes of competition law. We start with TOPCO, a group of smaller grocery stores and grocery store chains create an association that's going to act as a purchasing agent. And their aim is to create a private label that would be distinctively the product, the property of the members of the association. They include in their agreement an exclusive territorial licensing provision that says each member will be able to use and offer the TOPCO brand within a specific geographic region. The Department of Justice challenges this, and the main theory of harm is that this is a per se illegal allocation of territories among direct competitors. The Supreme Court ultimately agrees that that is the appropriate characterization and condemns the arrangement. And what I'd like to ask our group is to spend a few minutes, and we'll give everyone a chance to come in on this. Would you reach the same outcome today, looking at this set of facts? And would you get there through the same process of reasoning? And Sandeep, can you kick this off for us, please?
Yeah, thanks so much, Bill. Thrilled to be on today's program. So TOPCO is a decision for which I have very mixed feelings. So as a basic matter, I think the DOJ was wrong to bring this case. It was a questionable exercise of prosecutorial discretion. They were targeting horizontal coordination among small players. You know, as you said, TOPCO allowed small and medium-sized grocery stores to maintain their independence while coming together to develop and market private label brands in competition with large chains like Safeway and Kroger. So they were collaborating in a discrete area while otherwise maintaining their independence. And I wanted to get a richer sense of the facts here. So I went back and read the district court decision, and I noticed the district court made an interesting observation. The government concedes that if TOPCO, rather than being a buying organization for smaller local and regional chains or a single larger national chain, none of its practices would be objectionable under the antitrust laws. It also concedes that TOPCO's private label program enables its members to compete more effectively, both with the larger national chains, as well as with other medium or smaller regional or local chains and independents. So the court recognized something. Antitrust allows large corporations, including large corporate families composed of many separate corporations, to engage in activities that small firms cannot do in concert. I think that's a rule that deserves greater scrutiny and has too often been taken for granted. We assume that large corporations are simply more efficient and should have autonomy, whereas small firms, when they band together, are doing something suspicious. So on the grounds that I just described, the district court ruled in favor of TOPCO and said, on net, this is promoting competition. This is not the type of restraint we should be attacking under the antitrust laws. The Supreme Court reversed and held that TOPCO and its members committed a per se violation, horizontal allocation of markets. And the court made an interesting observation. The court said that the type of balancing that the district court engaged in is really not the appropriate province of the judiciary. So the Supreme Court has this interesting language saying, if a decision is made to sacrifice competition in one portion of the economy for greater competition in another portion, this too is a decision that must be made by Congress and not by private forces or by the courts. So the Supreme Court recognized its limits as an institution and thought that this type of balancing should be done by the national legislature. So I think my two takeaways from TOPCO are, we really need a more nuanced and subtle approach to horizontal coordination. I don't believe it's the supreme evil of antitrust. In fact, Congress doesn't believe it's the supreme evil of antitrust either, because it's granted exemptions to groups like workers, through the Clayton Act and Norris-LaGuardia Act to engage in horizontal coordination, similarly to farmers and ranchers through the Capper-Volstead Act. But these are decisions that ultimately need to be made by Congress. The courts have played an outsized role in American political economy in general, and I think it's especially true in antitrust. And we need Congress to decide what's beneficial coordination and what's harmful collusion. And so I think that outcome in Topco is unsettling, but the court was right. Antitrust law requires a judgment of the elected representatives of the people, and it's too important to be left mainly or exclusively to judges who are neither publicly accountable nor in possession of any particular expertise relevant to the field.
Sandeep, thanks for getting us off to a great start. Carl, if you could come in on this, please.
Thank you, Bill. So as the neo-Brandeisians have come into the ascendancy recently, I've looked very carefully at Louis Brandeis. I think we can learn a lot about Topco by quoting him from Chicago Board of Trade, 1918. Every agreement concerning trade, every regulation of trade restrains. To bind, to restrain is their very essence. The true test of legality is whether the restraint imposed is such as merely regulates and perhaps thereby promotes competition, or whether it is such as may suppress or even destroy competition. Then he goes on to say you have to look in detail about the effects and what's going on in the industry, which is what he did. And he created a Brandeis brief. So that's what the district court did here. They looked at what happened. One of the fascinating things about the Topco is the district court did a rule of reason. They looked closely at what was happening. And the Supreme Court then said, well, that's not what you should have done. We don't want to look at what actually happened. This is per se illegal. The Supreme Court quotes the district court for the following sentence. Whatever anti-competitive effects these practices may have on competition in the sale of Topco private label brands is far outweighed by the increased ability of Topco members to compete both with the national chains and other supermarkets operating in their respective territories. Hence the balancing that Sandeep referred to. But the Supreme Court does not quote the very next sentence in the district court opinion, which says, and I quote, moreover, if the testimony of all the live witnesses at trial is correct, the elimination of the Topco territorial limitations in the franchisees would result in the demise of the Topco organization and its private label program, with no benefit of competition in those private label brands, and a substantial reduction in competition between its members and both the national chains and other supermarkets. So the district court on the facts finds there's no balancing needed. Now, in terms of what I think of all this, if we do a rule, but the Supreme Court, if you look at the findings below, it's clear that the Topco enterprise was pro-competitive. Okay, that was the findings. Now, the DOJ did not put on any live witnesses. They just brought a per se case. They could have brought a case and said, we don't think these territorial restrictions are necessary for the operation of Topco. There were some coextensive territories where there was more than one Topco member selling Topco branded products. If they had brought that case, maybe they would, if they put on evidence, we might have a different record. But in the record, it was clearly pro-competitive. And the Supreme Court only went the way they did based on legal formalisms, horizontal agreements per se, which is exactly what Louis Brandeis rejected. I would say today there is a way to handle this. My writings try to offer a positive way forward to have more vigorous antitrust enforcement, but with sound principles. I would say, in response to Sandeep, actually, if a group of smaller competitors gets together and wants to engage in concerted activity in order to better compete against their larger rivals, and in fact, very often replicate what the larger rivals are doing on a unitary basis, that's the case of Topco, then a rule of reason analysis should apply and not a per se treatment. Price fixing would still be per se illegal. That's not a way to compete more effectively against your larger rivals. But this type of joint venture or collaborative agreement to compete more effectively should at least get rule of reason treatment. So I think the Topco court was in error in that respect.
Thanks, Carl. That's great. And I'm grateful to both of you to draw out the fascinating foundations in the district court that lay beneath a lot of the discussion and in many ways aren't drawn out in the Supreme Court decision. That's really helpful. Diana, please.
Thanks, Bill, and thanks for having me on the program today. Good to see everybody. I want to add a kind of a different angle here on what's already been said. And that really is to say, well, how would the case have turned out if it were to play out under today's market conditions in the retail grocery industry? And the hope would be that the decision would be the same, that this is a per se violation with no redeeming pro-competitive benefits attached to it. But I think the observation here is it would have been a much tougher case for the plaintiff given the circumstances today. And those are that we have had massive consolidation in retail grocery with very large chains and relatively unbridled concentration arising in regional markets. This all happens at the FTC, as you know. The big boxes and the large chains engage in lots of discriminatory practices, which are designed to ice out smaller independent grocers, things like discriminatory packaging policies, volume discounts, stuff that the independents just can't pull off as smaller scale types of market players. All of this would be a tougher sell today because of consolidation in the large actors in retail grocery. So any agreement like what we saw in Topco, for which the pro-competitive argument is that it allows the smaller players to compete more vigorously, would really be front and center today, given the deterioration in market conditions. So that's number one. I think that whole balancing under the rule of reason would have been a much more intensive debate if the case were to play out again today. Second, I would ask for the very small portion of restraints that are per se illegal, and that list has been whittled down clearly over time. Look at resale price maintenance and the like. What does this say about the type of competition that we worried about in Topco? It was really future or potential competition in Topco that was at issue, right? Expanding into other territories or a prohibition on expanding into other territories. We see a lot of issues today that relate to potential or future competition, right? And not only in digital tech, but in other sectors as well. So if the case were to be replayed today, but in a different industry where potential competition is really at front and center, then it does make us wonder how the arguments would have gone for both sides.
If I could just ask for a second, Justice Moss, as you sit on this exalted panel, do you cast a vote to exculpate the independents, or do you condemn them with another standard?
Yeah, I would hope the outcome would be the same if this case were to play out again today. Despite the plight of the independent grocers, I would hope that a per se restriction of this magnitude would be viewed similarly by the courts.
In addition to the hot tub, we could say we're sitting in that wonderful marble building in back of the Congress built in back of the Capitol. This is the conference of the court, and we're just chatting among ourselves about what we do here. So thank you, Justice Moss, for responding to that question. If I could turn next to Maureen, please.
Great, thanks, Bill. Thanks for having me in this interesting discussion and interesting format. A couple things. One, just the fundamental question. I would hope that this case would turn out differently if it were litigated today. I would hope the DOJ would never bring a case like this. I think that the idea of these formalities being placed on what seems to be a pro-competitive kind of approach where you might need some ancillary restraints to allow these, essentially sort of a joint venture kind of thing to operate would be get a better understanding in the courts and in the agencies today. I do think that I disagree with Diana about the state of competition in the grocery industry for consumers today. I think consumers have a lot of different options available to them. And I know this is all based on the question of consumer welfare standard, and I think we need to look at the consumer choices there. When you look at the ability of new competitors in the market, like Aldi, like Lidl, to come in and really disrupt, and we'd seen it previously with Walmart and other players kind of going back in time. But then, one thing that Sandeep had focused on that also really caught my attention, because I think this is important, that and will become important even more as we turn to the next case about the washing machines, where even this court, the Topco court, said, if a decision is to be made to sacrifice competition in one portion of the economy for greater competition in another portion, and I might add for, even for other values in another part of the economy, that's a decision that must be made by Congress and not by private forces. And I think that is a very key, even though I disagree with the outcome of Topco, I think that's a very important point to be made that needs to be part of this discussion, which has to do with who is the right decider, who is the expert, separation of powers issues, and legitimacy of the antitrust agencies taking on a wider role. So I think Topco has lots of interesting things in it, but I don't think that, I would certainly hope it wouldn't be decided the same way, or even brought the same way today.
No, thanks, Maureen. I just note that Justice Blackmun in the case had a concurring opinion where a point that all of you have touched on certainly came to mind for him. He says the bigs, he's talking about the other grocery store chains, he says the bigs should find it easier to get bigger. And as a consequence, reality seems at odds with the public interest. But then he says, I think I'm cabined by the existing doctrine and I can't do anything else. But there's an evident discomfort on his part as well in deciding that you're going to pull the trigger using a per se rule. To go through our panel of justices, we have not had an economist on our Supreme Court, though Fred Genee shows that courts can do that in other countries and function well. But Dennis, if we bring you in at this point, what do you think about the outcome and about the reasoning, please? Just the mute button, please.
Okay, sorry.
Perfect.
I think the case was wrongly decided for a variety of reasons, many of which have been already touched on. But first, I don't see how this can be considered per se. It is not the type of conduct that is a naked restraint that invariably harms competition. The court decision makes it clear there are other factors going on. In particular, the district court made it clear that this wasn't a restraint that didn't have some offsetting value. And if there's an offsetting value, it's not the typical type of restraints that a per se rule should be designed to address. Second, this case, reminiscent of, unfortunately, the recent American Express case, is an instance where the Supreme Court seems to completely ignore the district court's finding that, in fact, the conduct is pro-competitive. I agree with that point that Carl made. And that strikes me as improper, not only improper, but it is interesting because the dissenting opinion by Berger seems to get it exactly right. He goes through the economic justifications for what's going on. Again, it reminds me of the American Express case where I really like Breyer's dissenting opinion. What's interesting to me, especially in hindsight in looking at this, is we know the Supreme Court subsequently went on in decisions like, for example, BMI, to recognize that coordination among independent parties can sometimes be justified and pro-competitive if a new product comes out. Now, if you look at the history of Topco, and I went back and looked at some of it, before Topco was created, these private label products didn't exist. That is, the existence of Topco enabled these new products to exist. And in fact, Don Turner, the economist, the lawyer who brought this case, I think he was the attorney general, assistant attorney general, admitted that this was a deficiency that he didn't anticipate, and that in light of the Supreme Court decision later, he thinks Topco was wrongly decided. So that has to do with the per se rules and what the Supreme Court did and how it ignored the rule of reason. But then if you just look at the underlying facts, if you believe them, I'll come to that in a second, the market shares are so low, I would say, even though I'm not a big fan of market definition, if you assume these shares are remotely correct, why should I worry about this? I'm worrying about stuff that can't possibly matter very much. So I'm left by saying, even under rule of reason, I would agree, but I might have been even more positive than Judge Will in the district court in having to need to do much balancing, because even though he did talk about that extensively, the shares are pretty low. But let me just end on something that Diana brought up. It's kind of an interesting historical note. The question is, are the economic justifications that Judge Will endorsed, finding that it was pro-competitive, did those turn out to be true? So you can go in history and ask, well, what happened to Topco? Did it disappear? The answer is no. It's still a thriving firm. So any suggestion that it needed these restrictions to survive, that's too strong. And but still, even if you accept they would have survived, my view is with this low market power and the rule of reason, this clearly was incorrectly decided because it failed to use the rule of reason and instead used the per se rule and ignored the findings of the district court.
And you point out, Dennis, the interesting subsequent jurisprudence that might suggest that at least we'd have a different methodology coming out of BMI for testing the restrictions. I guess what is intriguing about the case is that in 1990, in the Palmer Bar Review case, which didn't seem to involve any plausible justification, the court says horizontal allocations of territory are per se illegal. And what case does it cite? Topco, as though that were the only thing going on in the case, which makes one wonder, as they've written later decisions, how do they situate these cases in the stream of jurisprudence? And Topco is cited as horizontal allocation of territories. Is that all that was going on, or was that the court writing a per curiam opinion, just having sort of a bad day at the office and not thinking very hard? Tommaso, the notions at issue in these U.S. cases are not completely alien to global experience, and the EU has a large jurisprudence and experience with the rough Section 1 counterpart, that's Article 101, and the criteria that allow some relaxation of the categorical ban on object offenses in subsection 3. As you read this decision, what do you think about the result? What do you think about the methodology in Topco?
Thank you, Bill, and hello, everybody. I don't know much about a case run in the United States half a century ago. It's a bit old. I think I should say more so we can move on to some other questions. I will just comment that we don't have largely disagreement on the panel on this one. My view is that today we would not run a similar case in Europe for sure. This is not one of the priorities that we have in general in the European Union or in the competition policy. From the economics point of view, there is alignment on the panel. Territorial restriction with such a per se treatment, I mean, they don't come out of the economic literature at all. Plus, there is a common sense, small market shares, where is the harm? So I don't think a case like this one would ever be run today. If anything, we have a different problem with the large retailers now, not certainly with the small ones. So the emphasis would be in a different place. And also, I think the European system is flexible enough to accommodate this. You mentioned it. Of course, we have restrictive practices which are sanctioned by Article 101, but then there is paragraph 3, which gives exemptions. And so this can easily be one of those instances where an exemption could be sought in order to be approved, as we've done in several occasions. So this case would not be run. The only thing that Europe is very keen on is on preserving the single market. So if these territorial restrictions were to affect the integrity of the single market, which means different countries, but so if a restriction could affect the trade between Germany and France or something like this, that would be seen in a different perspective. But I don't think that the Topco case has any of such features. So I don't think it's particularly controversial nowadays.
No, thank you, Tommaso. And we'll come back to you very soon on one of the interesting applications of this concept, the washing machine case. I'd like to just ask the whole panel, and any of you want to come in on this, please do, just jump in. But Justice Marshall has a very gloomy take on the capacity of the courts to deal with what he refers to as difficult economic problems. He says the fact is courts are of limited utility in examining difficult economic problems. Is that a fair assessment in your eyes in watching courts? And some of you have watched courts from the witness box. You have watched them in formulating enforcement programs. How true is his assessment of the capacity of our judicial system to deal with any factor you want to choose, but to deal with the analysis of complex economic problems? Is that a fair take? And is that the justification for using, a good justification for using bright line rules to decide antitrust cases?
Well, I think bright line rules make it easy for the judge, but it means that you are could well be giving up a lot in situations where you think a discretion would allow someone to improve matters competitively. I mean, there's no doubt it's difficult for judges and juries to evaluate complicated economic cases, and you often have cases where, well-respected experts appear on opposite sides. And one of the values of a hot tub like we're having here is when that happens, you can try and narrow why they're disagreeing, but there's no question there can be hard, complicated decisions. But I don't think just because the world is complicated that we should do things like say, you have to have very bright line rules that prevent discretion in circumstances where you hope reasonable people could come to the right conclusion. The only thing I would add is I found the FTC and DOJ, they're obviously more sophisticated because they have staffs of economists than a jury or a judge. But, and Carl and I both teach in a course where we teach antitrust to judges and district court judges, and I recognize the difficulties they face. But my experience is that a good economist should be able to translate into common sense what he thinks is going to happen based on sophisticated models. And that if you can't do that, if you can't explain something to, your parents, for example, or your kids who aren't economists, there may be something wrong with your economic case. So I think the sophistication can help buttress common sense. And that's what an expert should be doing, using sophisticated models and then be able to explain them in common sense ways. And that's my hope. Otherwise, you really have to give up.
Bill,
In
on
the
this
queue,
one,
go ahead.
I will.
Tommaso, you're next. Go ahead.
Yeah, I will disagree on this one with Dennis in the sense that I do favor more and more, having seen the practice of economics at work coming from an academic environment, I do favor bright line rules as a response to a political economy environment where theoretically reasonable economic approaches have yielded distorted and typically under-enforced outcomes. So there is a resource constraints that enforcers don't have the same firepower that many of the consultants have. And so we see some discussion which are led just by the number of people you can put in the discussion. So as an economist, I see the advantages actually of having bright line rules in order to avoid the discussions that have nothing to do with the realities. It's very different from what Dennis said, becomes over sophisticated discussions that judges don't understand, and they yield the results that they have yielded, which is in the past 30 years progressive under enforcement of antitrust in our economy. So we have seen it in practice how this has panned out. And so because of the practicalities, bright line rules are the way to go. And this is coming from a very orthodox economist, actually.
I've got Carl, then Diana. Carl, go ahead.
So I've testified in a good number of cases, almost all for the government in recent years. And I see a wide variety among the district court judges in how they handle or process quantitative information generally in economics. So I hesitate to generalize, because there's so much differences. But I certainly have seen cases where I thought the courts had difficulty. And as Tommaso says, they often see perfectly well-credentialed economists on both sides, and they don't know what to make of it. So that's just kind of this war of the expert. But I'm not willing to go with a whole bunch of per se rules. I just think we'd give up too much accuracy. It would just be a step backwards. So what do I recommend? First, some degree of judicial training helps. Perhaps, and this has been proposed, specialist panels to handle some of these cases. I will say what the UK does. I testified once in front of their competition appeals tribunal. I was very impressed with the 3-judge panels there. So that's another way to go. But working with the existing system without that would be a big change, obviously, procedurally, and require Congress. Just within the existing system, a series of rebuttable presumptions with more focus that would favor plaintiffs and government enforcers more. That's my response to, I agree with Tommaso, we've had this drift in an anti-enforcement direction, but that doesn't, you can reverse that without going to per se. You can have rebuttable presumptions. And a good example would be the activist case, where I really appreciate the Supreme Court ruling that favored the FTC being able to bring these cases. These are pay for delay pharmaceutical cases. But they could have been so much sharper in terms of there's a rebuttable presumption that a payment, any transfer of value from a branded to a generic is anti-competitive, and a very limited ability to rebut that for the defense. They didn't go there at all. They threw things wide open and have made a mess in the lower courts as a result. So that sort of thing could be avoided.
Yeah, I flinch at the missed opportunity there, Carl, for the court to have said more. I see in the opinion, and this is the reverse payments Supreme Court decision, the frustration of Justice Breyer being unable to get the additional vote to go with him to provide the guideposts, and thinking this is the best I can do. Exculpation is not the answer, but I can imagine him saying, I teach this stuff for a living. This has been my whole life. For God's sakes, I know what I'm doing here. Give me the benefit of the doubt, but not getting the additional vote on that. Diana.
Yeah, I just want to point out that the economics of the Topco case, weren't very complicated. If only those judges could be around today and looking at the big tech cases, Facebook, Google, looking at some of the big vertical merger cases like AT&T, Time Warner. Boy, it makes you wonder how they would view the complexity of the economic landscape behind these cases today. There's no doubt in the Topco case that an association that was designed to ensure quality control and reap the benefits of bulk purchasing and the consumer bump in demand for trademark products. I mean, that's all legit, absolutely legitimate stuff. The key question in the case, of course, is did they have to engage in territorial restrictions to deliver that? And I want to also point out that the major reason they engaged in this restraint was so that they could compete better against their bigger, larger rivals. And that is a very slippery slope. We see it in Section 1 law, we see it in Section 7 law. And this is where education, judicial education, is really critically important and the arguments that are made. But for example, mergers that are justified primarily on the basis of bulking up to be able to better compete against your other rivals, that is commonplace now. Look at the recently announced merger of Spirit and Frontier. That merger is motivated entirely, if you read their public reports, by a need to bulk up to be a better competitor. Okay, so when does that all stop? That's a slippery slope. As consolidation and concentration increases, and this justification is offered up again and again and again, ultimately you could end up with a duopoly in every market that we care about, right? Same thing on Section 1. If this restraint in Topco was allowed to move forward for the reason that they needed to be better competitors, then other agreements would slip under the radar screen. And before you know it, we'd have a bunch of rivals colluding or coordinating in fundamentally anti-competitive ways. So I think when it comes to the role of economic analysis and how judges view this, the snapshot in time approach is becoming more of a liability, because as we see markets consolidate and concentration grow, not in every market, but in some really critical markets, it's going to be really important for judges to consider what the motivations for these types of mergers and conduct really are, which is to be bigger so you can compete better. That's not a particularly legitimate justification for those types of economic activities.
No,
Diana,
thanks,
are
Dan.
you
I
rejecting
wondered,
Bill,
go
just
ahead, Carl.
are you rejecting seems like you're rejecting the findings of fact in Topco about the necessity of the territorial restrictions based on the executive testimony, 2 experts on supermarket merchandising, and no live witnesses by the DOJ. I agree that that's an important finding, but that was the finding. So I'm not sure what you're saying when you say the economics here is straightforward. That was a factual finding about economic effects. So is your whole view based on rejecting that?
No, I should have been more clear. I'm not rejecting that. I think the economics of this case are very straightforward. I'm thinking more about the increasing complexity of cases over time, right? As we move into non-price effects, for example, quality effects in digital tech Section 2 cases, elimination of double margins, for example, in vertical merger cases, which, as you know, Carl, can be highly controversial. So it wasn't so much a fact-specific comment, but more of a larger observation about growing complexity in business models and economic behavior.
I would just add
I'd like
that
to-
there's something different I thought you were saying, and I've written about this, so I wanted to get your view. I don't think this has anything to do with Topco, but you do see a lot of justifications for mergers by saying, well, I have to get large because I have to negotiate with the other side, and they've gotten large. And then, of course, you hear the other side saying, well, I have to get large because the other side's getting larger. And it all comes because I can better bargain. Well, that makes me a little nervous because, you wind up with one firm on each side if you believe that argument. So that is almost saying I don't believe in the process of competition, that competition is going to work. I think that is a concern in some of the cases that I've seen when you listen to justifications for why people are merging. And I think, people should pay attention to where that leads in a dynamic sense. In terms of presumptions, I think it's right, but there's a point I want to make about it. you can move presumptions over time based, and this is what I think is critical, what is scholarship telling you about what happened? What happened in this case? What happened in that case? And as you learn over time, that's how your presumption should change about what you think is acceptable behavior and what you think is not acceptable behavior. It also changes the confidence you place in the methodology that economists are using. Are they using a methodology that in the past turned out to be correct or not? So on this per se versus discretion, I think it's right that we use our learning to alter the presumptions that judges use when they come to cases, but it really should be based on what I think is the continuing accumulation of knowledge based on past behavior, past cases.
I'd like to ask Sandeep and Maureen if you'd like to come in on this issue of institutional capacity. That is, who should do what? What's the appropriate role for the courts? Whatever our aims, our objectives are, do we have the right technology in the field of decision making to come up with good answers here? Is Justice Marshall's lament correct? It's just too hard, so we need really clear rules. Or are there methodologies we can use, institutions we can use to take into account more fully other considerations, and maybe on Tommaso's point, by bolstering the capacity of the institutions entrusted with enforcement and decision making? Do you have thoughts about this institutional question about the capacity of our system?
Yeah, so like Tommaso, I strongly favor bright line rules and have deep concerns about the rule of reason. So part of my objection to the rule of reason is courts are forced to make extraordinarily complicated decisions, often weighing unlike quantities and qualities against each other. And these judges are generalists. They don't have any generally don't have specialized training in economics, finance, or accounting. But I think it goes beyond that, because judges are being asked to make value judgments. How can firms cooperate? How can they compete? And I think Justice Marshall got it exactly right in Topco when he said, to analyze, interpret, and evaluate the myriad of competing interests and the endless data that would surely be brought to bear on such decisions, and to make the delicate judgment on the relative values to society of competitive areas of the economy, the judgment of the elected representatives of the people is required. So he realized these are not technical questions that can be resolved purely through technical means. We're implicating normative questions. What does our economy look like? And we live in a representative democracy, and these questions should be made by Congress. And I think this is a problem that extends beyond antitrust, but the American judiciary is extraordinarily powerful in deciding these basic questions of political economy. Came across this nice quote from Sabeel Rahman and Kathy Thielen, where they said, compared to other rich democracies, the American judiciary is more powerful, more politicized, and more directly involved in shaping outcomes in the political economy. So I think that's probably most acute in antitrust, but we're punting important questions to the courts. And I think we saw this in the recent Alston decision, where the Supreme Court, as well as the lower courts, weighed the demonstrated injury of the college athletes against purported benefits to college sports fans. These are questions that the courts shouldn't be making. Congress should be making these decisions one way or another.
Thanks, Sandeep. Maureen.
Yes, so I mean, kind of pulling this back to the question of the consumer welfare standard, I think trying to adopt a standard that accounts for all other societal values only exacerbates that problem of making a difficult decision and a more politicized decision. So I have definitely concerns about that. But I also think one of the great strengths of our historic approach to antitrust has been the flexibility that was built into it, right? This is not a, formalistic, and we've moved away, right, from strict formalized rules. Now, I also think one of the other things that's a little bit misunderstood is how some of these presumptions work. They don't work, in isolation. Christine Wilson has with Keith Clovers has an excellent piece about how, as we've gotten more and more narrow market definitions, it's actually these presumptions have made antitrust enforcement even more strict, more rigorous, and the challenges of showing out of market efficiencies, because the market's so small, even higher. So I don't like the idea of saying, well, let's do that even more, and let's take the flexibility out of our system, because I think we have had a very dynamic economy with a lot of flexibility as we've moved away from some of these economically, let's say, untethered kinds of approaches to things. But on your point about institutional capability, the thing you mentioned activists and how, the courts made a mess of it. Well, the FTC should have never put those cases directly into court. They should have brought them in the Part 3 process and given more content to what a rule of reason approach.
This is the administrative adjudication mechanism. At the
Right,
FTC.
it's exactly the administrative adjudication, and given the content to what a rule of reason approach looks like in a pay for delay case. So I don't think that's a reason to say we need more bright line rules. I think it's a reason to say the FTC should have used its comparative advantage to do that. And in the AMG case, Justice Breyer cited a speech that I had given called Dollars, Doctrine, and Damage Control, how the FTC's pursuit of disgorgement impacts its competition mission, which essentially made that argument that I just made, which was by pursuing money in court, the FTC really lost an opportunity to define what a rule of reason approach in a pay for delay case should look like. So and when you're talking about some of the institutional capabilities, I just put in a plug for the FTC's much maligned Part 3 process, but that it has that kind of benefit.
Let's go to washing machines for the next segment. And here, this is a case from the late 90s in the European Commission, DG Comp, where we have a collaborative effort by appliance manufacturers to withdraw the production of more energy-intensive models to encourage consumption of more energy-conserving models, and with the effect of taking what would have been lower-priced washing machines out of the market, replacing them on the whole with higher-priced machines, declining to import the more energy-intensive models, with the rationale being this will serve a valuable purpose of reducing a serious negative externality associated with energy consumption. And using the methodology that Tommaso referred to before, the commission found this to be an appropriate form of collaboration. I guess a question that washing machines raises, Tommaso, is I guess a couple. One is from your perspective in Europe, is this a sound analytical approach for the commission, other decision makers going ahead? Does this foreshadow the greater consideration in competition cases of negative externalities that arise, for example, in the environmental policy area, as a way, for example, of saying, what do consumers want? Consumers want a clean planet. They want to be able to live. Are we going to see the incorporation of these kinds of concerns more generally into the decision of competition cases? Tommaso.
Thank you, Bill. I'll respond to that, but sorry not to play according to the script, but
you can go off script. It's
sure.
Okay.
I always
do.
Do.
A good seminar.
I always do. Because the discussion is a bit weird, I think. We're discussing about Topco, we discuss about washing machines. I think these are really narrow cases we started discussing per se, but apply to. So so I think we do need a system of bright lines, a system of rebuttable presumption. Where the problem is not Topco, the problem is not washing machines, the problem is very large dominant firms with market power. That's where I want to have a system of rebuttable presumptions. Okay, not to Topco. I mean, I don't care too much. It's not an economic and a political priority there. And I'm very happy to have also on the side a system of safe harbors for firms with very small market shares. That's absolutely fine by me, because we cannot go on and say let's analyze case by case, because enforcers don't have the resources to do that. So let's prioritize what's relevant to our society. And I know that people love to talk about precedents and weird legal cases, but I want to be more pragmatic and see what the problem in our economies currently is. Now, when it comes to sustainability, green stuff, and the washing machines, so these washing machines, indeed, it was seen that the environmental benefits to society were larger than the possible cost of withdrawing some washing machines. It's a case of 1999. There hasn't been anything of this kind in the next 20 years. I think the pendulum is shifting again. But let me say a few things up front, because I would like people to be aware there is another dimension of this discussion here. First, when we're talking about the environment, obviously we're talking about a gigantic problem which involves externalities, and it involves also intergenerational transfers, current generations versus future generations. So there we need a system of taxation and subsidies. And that's what, maybe it's one of the few areas where there is agreement among economists that this is the way to go. And I do see a big risk of greenwashing here. So all of a sudden, it has become of interest to see whether we can relax competition policy to take into account environmental concern. And usually it's always in the direction of having less enforcement, because otherwise we cannot allow firms to do fantastic things. Let's have less enforcement, as if we had a lot of enforcement until now. And that's exactly what the British Petroleum, the Exxon, these other companies want to hear, because there are political priorities, which is to set high carbon taxes or subsidize adoption of green technology, but they don't want to have that carbon taxes. So this is diverting the attention. Say, don't impose now carbon taxes, because we can do marvelous things via competition law if you allow us to do. Let us talk to each other, and we will find a solution for society. And this is very dangerous. And I hope the profession is aware of that we have economic and political priorities, and we should spend our resources where the problem is. Second, very curious fact that the legal profession of antitrust is super interested in relaxing competition policy in this respect. And surprisingly, or maybe not surprisingly, in Europe, it's the same lawyers from the big law firms that were attacking the Commission for adopting within the consumer welfare standard things which were not only static price effects, but we were doing innovation theory of arms, we were doing consumer choice in Google. The same lawyers of those companies are now there to say we should relax competition policy to take into account environmental externalities. So it's curious that somehow they are their own standards, where they were asking us, the burden of proof was really to show, are you sure that patents is what matters in an innovation of theory of arms? That's not enough to measure the impact. Now, instead, they can go all the way without any estimation of anything, because that's convenient for the clients. The other thing that I should say, which is really curious intellectually, when we are talking about adoption of greener technologies, which are obviously are bringing positive externalities to society, a market system basically is not enough. You want prices to be low to encourage adoption. How on earth, by allowing less competition, you're going to have a positive impact on adoption? So the narrative that we are being told is that firms fear the impact of competition policy if they talk to each other. So, which is really funny to me. So really, I would shift the burden of proof on those who want to relax a competition enforcement, which is already lacking by a lot, and to see why do I need to listen to them to understand what is the fear that is it really that they fear these super enforcers and that's why they're not bringing to the market. Competition to me is a way of bringing prices down, of bringing more innovation, including innovation in greener technologies. So I'm really surprised, or maybe not surprised, that this conversation is happening. And in fact, the conversation is not being led by Greenpeace or advocacy groups. It is led by the very conservative lawyers which are defending the corporate giants, and they see this as a useful tool to relax an already very lax competition enforcement field that I have personally witnessed over the past many years.
I guess on that, Tommaso, I've seen recent presentations by folks like Michelle Meager, Simon Holmes, whom I would not associate with that cohort, who are fairly adamant in saying that competition policy has to take into account the externality concerns, and that it deserves to be front and center in the analysis. Am I misinterpreting them?
Well, you should ask them. I don't think you're misinterpreting them. They are saying that we should do a different type of economics, because economics allow also to put a price on the value of clean air and those sorts of things that exist. These are not tools which are used in antitrust analysis. They generally are saying that the standards which use should be, more open than the usual price effects. And I'm totally in line with Michelle and Simon. But also, I don't think they see the other aspects which I was mentioning earlier, which is the greenwashing effect. And I see over and over, I'm currently not involved in any antitrust case, but I am on the board of the Financial Conduct Authority, and I see the same thing happening there. I see the new financial instruments that should be approved by the financial regulator in order to improve our society from the environmental stuff. And this is constantly pushed in order to delay the adoption of a more serious discussion on carbon taxes.
Sandeep, do you have some thoughts about taking on the kinds of concerns about environmental externalities and deciding what kind of collaboration is appropriate?
Yeah, so I would echo much of what Tommaso said. So I reject the idea that we should be doing open-ended cost-benefit analysis on a case-by-case basis under the rubric of the rule of reason. I think it's completely unworkable. It's a really absurd way to administer system of law, and this is antitrust law, not antitrust applied economics. And instead, a much better approach is to have a series of per se rules, presumptions, and yes, safe harbors. And I agree with Tommaso, we also need per se rules and presumptions for dominant firm behavior, not simply for horizontal coordination. And I think the washing machine case is an interesting one. For me, it's on the borderline between beneficial cooperation and harmful collusion. So my understanding of this case is, the firms are really trying to shift competition away from sticker price competition, where consumers are simply buying the cheapest washing machines. These often use a lot of electricity, not particularly good for the environment. And they're trying to shift competition more toward efficiency, life cycle costs. How much does it cost to not only purchase, but operate a washing machine over its entire 10 or 15-year lifetime? So it seems desirable in a sense. They're trying to shift competition to a more socially beneficial dimension. But part of me wonders, why aren't they already doing this? Why aren't one of the big manufacturers leading by touting the energy efficiency of their washing machines? Why do they need to come together to achieve this industry standard? So at a minimum, this type of coordination among firms, what I gather is an oligopolistic market, needs to be subject to some type of public oversight to ensure that they are coordinating on what they stated that they would coordinate on, rather than price or other terms that might be more suspect. This could be handled through something like the business review letter process in the United States. I gather there's something similar in Brussels. So I think this is very much a borderline case. In an ideal world, national legislatures, regulators would be mandating these energy efficiency standards. We wouldn't be outsourcing basic questions of public policy to manufacturers. But given that we're not in the best of all possible worlds, I think sometimes the regulators, especially when exercising their prosecutorial discretion, need to recognize that this type of coordination might be beneficial and not necessarily worthy of protection, but deserving of inaction.
Yeah, I just note that, again, I mentioned a couple of people have been involved in the debate. They would say, ideally, you'd have good carbon taxes. Ideally, you'd have good energy efficiency standards. Ideally, you'd have the first best solution at work, but they're not working. And that competition law ought to be a supplement to back that up, just to note their observation on that. Carl.
Well, I would take a much more strict antitrust enforcement approach than Sandeep. I don't think this is a borderline case. I think this is an easy case in which this type of agreement among competitors to withdraw products from the market should be condemned. Let's be clear, the agreement was to stop selling certain inefficient and low-priced washing machines. My view on the line, look, there are a lot of horizontal collaboration that's quite beneficial. A lot of standard setting, for example. Okay, my view, I think, again, it's not that complicated for the courts. Horizontal collaboration, if it's to better serve customers, to compete more effectively against others, then that's good. If it's to withdraw products or raise prices, and that's bad. Okay, so that's not that hard, I think. Now, in terms of the goals here, there are a number of things that they could have done that I would think would be perfectly allowable in terms of horizontal collaboration. You mentioned moving away from, I think, sticker price competition. Okay, well, it would be perfectly fine as far as I can see to have a group say, we are going to establish an energy efficiency standard. We're going to have an Energy Star type label on these things. And we're going to all agree what that looks like. And we're going to all agree that in order to get this label, you have to do something. But we're not going to stop you from selling other stuff. That's the difference. Okay, the energy label gives more information to consumers and then facilitates competition on that dimension to get the label with a logo, et cetera. Likewise, it could be perfectly fine with my sort of along the lines of what we have when you buy an automobile, is you could have a label that says total cost of ownership of this washing machine over the next 5 years, or how much electricity it uses per year, all that stuff. And that could be done collaboratively. I think that would be fine. It's more information for consumers so they can make decisions. So these goals can be achieved to some degree. Now, what about going the next step and just saying, no, that's not enough. People won't respond. We need to actually withdraw those products from the market. We need, because, okay, look, that could be a good thing. Of course, the government could pass a rule saying you can't sell a washing machine that's very inefficient. Okay, we have that with automobiles pretty much, right? With fuel efficiency standards. What I cannot accept, will not accept, is that we are going to cede private companies the power to make those decisions. Those are public decisions. Goodness knows, we have ceded way too much power to private corporations, both because they have too much influence in Congress and because billionaires can do all sorts of stuff and seem like they have too much power in our society. So I want to take away the power from the private companies, and this power to withdraw these products from the market should be something the public has that control, and Congress or state legislatures, I would say too. This could be done at the state level. And where's the stop? Okay, the oil companies get together and say, we're going to form a cartel because we're going to raise the price of oil, gasoline. Very good for the environment. Is that going to be allowed? What about the coal companies? Okay, they're going to shut down mines. What about tobacco companies? There's no end to this. We learned in the 1930s this didn't work. After the National Industrial Recovery Act, there was all sorts of permissible cartels, and it actually prolonged the Depression. So stop. No, Sandeep, this is not a tricky case. This is an easy case.
Anna.
Yeah, I think a couple of thoughts on this one. First of all, I think this washing machine case in the EU is really clever. They managed to exempt an agreement ostensibly on the basis of pretty straightforward concerns over anti-consumer impacts, but still managed to shoehorn in some of the environmental policy goals or concerns that were really at the heart of the case. I don't think you would have seen a similar situation in the United States. If you go back to National Society of Professional Engineers, right? The court there, which was really all about sort of limiting competitive bidding for the sake of producing very safe and high structural integrity buildings, where the court said the purpose of the analysis is to form a judgment about the competitive significance of the restraint, not to decide whether a policy favoring competition is in the public interest or in the interest of members of an industry. So I think if you transferred washing machines to the US, it would have been a very different process and likely a very different outcome. But even so, to the EU's credit, the analysis over there, they did manage to sort of sneak some of this stuff in under a traditional sort of consumer welfare standard. For example, they use life cycle costs of owning more efficient machines essentially as a proxy for price, right? So that's one way to get the analysis to reflect more embedded environmental concerns. I mean, other examples outside of washing machines would be looking at a degradation of environmental quality as a result of livestock mergers or mergers that consolidate livestock related facilities. When I was at the Federal Energy Regulatory Commission working under a public interest standard, we looked absolutely at the effects of withholding electricity output to drive up price, but also to assess the effects on reliability. So even working within a consumer welfare standard, I think there are clever ways to sort of shoehorn in these non-traditional concerns. If you're talking about policy, then there's three choices. One is to let antitrust do what it does best under a no harm to competition standard. Another is to change the antitrust standard to resemble more of a public interest standard, right? To include social goals, environmental goals. And another is to rely on other complementary policy tools, as we have just heard, several people discuss here. If the decision is going to be to change the antitrust standard, then I think you have to ask, well, where do these non-competition goals fit into the analysis? And I think they fit in directly through the efficiency side of the equation. Show the anti-competitive effects of an agreement. But then when you flip to the efficiency side of the ledger, right, that's where the hard thinking would have to happen about bringing in the non-competition goals. And by doing so, what you're really opening up sort of a Pandora's box of how do you measure non-competition efficiencies? And is the standard adequate for that or not? I think it also raises questions of administrability. How are courts going to look at non-competition goals as part of traditional antitrust analysis? So, the list goes on from there. I think this is a very, very, very difficult debate. And my own view is that we as a community and outside the antitrust community haven't really given enough thought to what other policies could be used or deployed to work in tandem with antitrust to achieve some of these bigger non-competition goals that are clearly things that people care a lot about.
Thanks, Diana. Maureen?
So let me say that I agree pretty strenuously with Carl about the fact that this shouldn't be a close case at all. I think that the idea that these competitors would get together to take, essentially a lower cost product off the market. And I agree with Sandeep too. I think that there were other ways that they could have pursued, doing this through certification or what have you. And the idea that they're going to kind of step in and take over the decision that I think should be made by a different part of the government who maybe has more expertise and maybe more of the public interest in mind would make sense. But what thing, building on something Diana said, I think this is really important to look at this through the lens of the professional engineers case, because I spent a lot of time when I was head of the Office of Policy Planning, and that was a little project of mine when I was the acting chair, focusing on getting rid of unnecessarily occupational licensing restrictions. And actually, I was very pleased to see that effort, those kinds of efforts to focus on unnecessary occupational licensing, was also made it into the president's executive order. But the justification that is so often used for the private actors to get together is a quality one, right? Is to say, well, we can't let those consumers make that choice to pick something less expensive or lower quality or something like that. That's just, it's not going to, that's not the best outcome. And by the way, in our own self-interest, as the dental board or the cosmetology board or whoever else, it just happens to fence out competitors and reduce competition there. So I would really have concerns on allowing this type of defense to take root. Look, the South Carolina dental case, which was settled at the FTC, involved, the legislature had made a decision that dental hygienists could go in and do cleanings and screenings in schools. And this was very helpful, particularly to lower income populations, minority groups as well. And then the dentists were like, well, that's not the best quality. So we're going to pass an emergency regulation that says that's not allowed. Right. So when you start allowing, private self-interested actors to make that kind of decision, I just really fear for where that ends up. And I think what we really need to do is say those kinds of, quality arguments and balancing really needs to be made by, the legislature or the regulatory body, the EPA or whatever, who has expertise in that, rather than purely made by the self-interested private parties.
Thanks, Maureen. Dennis?
Well, I agree with Maureen and Carl. I am highly skeptical that it would be desirable to allow voluntary cooperative action among profit maximizing firms that results in, say, an increase in price from a restriction on competition to be defended on the basis that it, quote, achieves a social goal, because they're defining the social goal. And let me just give an example. Suppose a bunch of firms get together and say, let's form a cartel. We'll engage in price discrimination. We're really going to raise the price on the rich, and we'll cross-subsidize and give it to the poor. Now, I should say a lot of hospital mergers sometimes were just, some hospital mergers might have been justified like that many years ago. I don't believe it. I don't want to cede control of that to profit maximizing firms. Profit maximizing firms have an incentive to maximize their profits, and I'm worried they will come up with all sorts of justifications. Now, there are well-known ways for horizontal collaboration to occur that can help the industry. Standard setting is a good example. We know you can misuse the standard setting process to harm competition. That's sort of radiant burners. But it's also the case that standards can promote competition. I think courts can figure that out, and I'd allow that, but certainly. But I would not allow the achievement of social goals. And I'll just say, I know time's running out, so I'll just add one additional thought. When legislation is being considered for types of agreements, say environmental, and there are hearings, and firms go and consciously mislead legislatures, either by lying to them or misrepresenting what they'll do under certain standards, that too should be attackable. And I'm not sure, I'm not a lawyer, but I know that's often protected under Noor-Pennington, and that troubles me. One of the ways in which you get coordinated, when I was at the Department of Justice, I forged a relationship, collaborative relationship with the Council of Economic Advisors. And every time, and also we had someone at OIRA, which is the branch of government that looks at regulations. And I said, a lot of these raise competition issues. Ask us for our advice before you make proposals, and we'll help you. That, I think, is the way to deal with these problems, not to allow voluntary associations of profit maximizing firms to say, don't worry about legislating us, we'll solve it ourselves. I wouldn't trust them to do that.
Tommaso, if I could come back to you with one
Sure.
question before our last round, which is, am I right that you see a deeper concern throughout the system that as you expand the range of considerations, that process is terribly prone to capture? That our institutional framework now does not have adequate safeguards to avoid the inevitable capture by the bar that you describe, the corporate interests. Is that a fundamental vulnerability for our system, and how do you address it?
So this vulnerability I have encountered personally on many occasions. It is a difficult one to solve. There are a few ways. First, by being more transparent. We lack transparency starting ourselves, the academics. We never disclose that we do consulting, although we always refer to when we were back working for the enforcers. So for some reason, our work for the enforcers is always mentioned. Our work for private companies never is. That's just a bare minimum. The other way of addressing it is, as I said earlier, to reinstate a system of bright lines, some rebuttable presumptions. I really want also, economics is telling me that it should be the large firms to tell the enforcer what they are going to do, why they need it, and to prove it instead of the other way around. So to me, the burden of proof has to change quite substantially if we want to move on. The US has also not a very healthy system of revolving doors. So in Europe, we are slightly better. In the US, it's pretty bad. But it's very difficult. Academia is not engaged. Because academia is working in different ways, doing publication in different ways. So academia is underrepresented, and instead you have a set of think tanks and lobby associations which are overrepresented in this space because it's a collective action problem. We are as academics independent. There is not such a thing as opinion of the academic community. Instead, the think tanks which are funded by the big tech or by the Koch brothers are prepared to be in front of every discussion which is happening in front of the FTC or the DOJ. And therefore, people which are not versed in economics hear that and they think that they are bringing to the fore what is the economic consensus. So this is a very difficult problem to resolve, and it's a fundamental one. So it's what academics have called a problem of thin political markets. So antitrust, in a sense, is not salient enough. It's very technical. Let's leave it to the experts. Let's leave it to us. But we are subject to influence like anyone else, and it's not in the more general discussion, which is led around, I don't know, taxation or immigration. The good thing, I think, in the past 3, 4, maybe 5 years is that the debate has changed. So the discussion among civil society has changed and it has become more salient. And I think this is great. So I don't think this is about populism. It's about politics. And it's always been about politics. And I think that's great that a larger number of people are forming views related to this. And I want to say a last thing, Bill, back to the washing machines in Europe. First, I disagree somehow that the US would be. This is a case that in antitrust. So first of all, it's a case from 20 years ago. It has not had an impact afterwards. In fact, in the successive horizontal merger guidelines, it was almost buried and ignored. So it hasn't made an impact until now. So things are changing now. So maybe we are back to that. In antitrust European terms, this is really an example where you can evaluate in-market efficiencies, because the claim in the washing machines is that indeed there was a price effect of withdrawing some certain inefficient price machines. However, the same users of washing machines would benefit from a cleaner environment, and methods were used. So this is a typical efficiency within our tools. It would be more difficult instead to run a case if they were out of market efficiency. So let me make a couple of examples. If to energy producers in the UK where I live where to meet in order to decide to adopt a fuel that was more environmentally friendly, that would impact on a large population because everybody is an energy user, and therefore that would be an in-market efficiency that could be addressed. Instead, if I don't know, two airline companies were to do the same on a certain fuel, that could increase, despite being more energy friendly, could increase the prices to some passengers. However, the whole world would benefit from less pollution because these are gigantic flying objects which pollute a lot. That would be much more difficult in the current European framework to include it. So this is clear. But and the last comment is Europe, and I think the US too, has political priorities, which is fine. I think it's fine to have political priorities. In the European Union, unfortunately, the UK is not part of it any longer, but the Commission sets political priorities, and then the Directorate implement within their tools the political priorities that the European Commission has set. And the European Commission is actually voted by the European citizens. So environment is one of those. Digital is another of the current political priorities, and so I expect DG Comp going forward to allow more and more thoughts to environmental concerns, and which is probably fine. It means that we will have to evaluate sometimes in quantitative terms, using tools not in the economics we do in antitrust, but economics in environmental application has a lot of those tools, or qualitative instruments, and then it will be a matter of judgment. So going back to your previous point of people like Simon Holmes or Michel Meager, Bill, I think what they are saying is that it will be up to judges to make judgments, and there will be more judgments that will be made in the next few years on environmental matters, including competition policy.
Thanks, Tommaso. Actually, they were talking about that Competition and Markets Authority being more involved, but I can come back. We have about a minute each for our other five panelists. A final reflection that you'd like to offer for people to think about on the question of why we do this and how the framework for doing it might be improved. Sandeep, please.
Yeah, thanks so much, Bill. I think it's important to reflect on something Tommaso mentioned. This is all fundamentally political. What does our society look like? What types of competition are businesses allowed to engage in? What types of coordination and cooperation are businesses allowed to engage in? There's no escaping that. Normative judgments need to be made. And as citizens of a representative democracy, I think as far as possible, these judgments should be made by Congress and congressionally established agencies such as the Federal Trade Commission, and judges who are neither popularly accountable nor in possession of any relevant expertise as a general class. Their role in deciding questions of political economy should be kept to a minimum.
Maureen, please.
Well, we have a common law system in the US, right? And Congress did set out some very general parameters, and the courts have interpreted them over time. And that, over time, they've moved towards the consumer welfare standard, even though that maybe there were some undoubtedly, there were different motivations initially to some of these approaches to antitrust law. I am actually a fan of the common law system, and I think it's perfectly appropriate for different voices to be part of that. I don't like the suggestion that if you, have a conservative voice, you're not, you're suspect, or if you, previously were in the government and now you represent private parties, that you should not be allowed to be part of that debate. And so I think that having this kind of ongoing iterative process, not that there can't be corrections. And one of the things that I found over time in my role at the FTC was to say, are we using the right tools? Are there any competitive things that we're missing? And how do we identify those? And, there's some really good examples in hospital mergers. Tim Muris did. I'm a big supporter of the activist case, just thought we could have done a better job getting it interpreted, what it means in practice. But so I have concerns about moving away from that case by case common law approach to one that seems, to my mind, to be a little out of step with, sort of the U.S. tradition in antitrust law and in a lot of laws. We generally do have that common law tradition, and I like the flexibility there, but the trade-off for that often is complexity or some uncertainty.
Dennis, please.
Well, I think I'd summarize my views by saying that the goal of antitrust should be the preservation and protection of the process of competition. I don't like to get involved with labels, consumer welfare, total welfare, this and that. I think they've been misinterpreted in the current political climate, even if among economists we could agree. Why do I think preserving the process of competition is desirable? Because it generally produces outcomes that have been viewed as favorable: lower prices in the short run and the long run, new products, incentives for innovation, and efficiency. Competition does not necessarily lead to the correct income distribution, whatever you mean by, quote, correct, does not lead to a decline in pollution, does not lead to paying attention to green policies necessarily, does not stimulate the macroeconomy necessarily, does not lead to optimal privacy controls necessarily, and bringing in all these other features, which are admittedly important, I think would be a mistake if you bring that into the antitrust tent. The reason is courts, the FTC, and the DOJ have a hard enough time figuring out effects, conduct on prices and innovation. That's all these past cases have been about that, and there's a lot of disputes, and we talked about some today. You start adding topics like income distribution, climate change, and as people to just put that in the decision making, you're going to get a muddle. You're going to get unpredictable decisions, and my fear is they'll be subject to huge swings in political thought. My own preference would be to deal with those important concerns, other concerns, in a different way through different agencies, legislation, but don't muck up antitrust with that. Otherwise, you're bound to wind up harming what antitrust has tried to achieve. That doesn't mean it has achieved, but its goal, if it were properly done. And I think it would be a big mistake.
Thanks, Dennis. Carl?
I think Americans have always placed a great value on competition and had and never liked monopoly. Our antitrust statutes, going back to the Sherman Act, talk about monopolization being illegal. They talk about the benefits of competition, and the Clayton Act talks about preventing mergers that substantially lessen competition. With those guidance from Congress, from the American people, these are economic concepts, and that is what we should continue to promote through the antitrust laws following those statutes. Now, the consumer welfare standard was helpful in its day because it made clear that when a firm, even a large firm, introduces a better product, for example, and that harms its competitors, maybe it takes over even a bigger share of the market, that is not illegal. That is part of competition, even though it may lead to a more concentrated market. That was unclear to the courts, and the courts fixed that eventually. That was part of the competitive process. The consumer welfare standard as a term has outlived its usefulness. I've been saying this for about 5 years. I testified at the FTC hearings on that in November 2018, and I explained this in some detail in my paper last year in the Antitrust magazine, Antitrust, What Went Wrong and How to Fix It. So I think Chicago school ideology has led us astray, through the courts astray, really. But if we follow protecting and promoting competition, those are economic concepts. That's what the statutes say. That's what we should keep doing. Protecting and promoting competition. That should be the guidepost. We don't really have a consumer welfare standard. A firm raises its price. That's bad for consumers. Well, that's not illegal. It's not a consumer welfare standard. It's about competition and protecting the competitive process. Now, that does not mean protecting small businesses, though. Okay, there are other values that competition does not necessarily promote, as Dennis said. So those are for other statutes. Those are for regulations, environmental regulations, sector-specific regulations, income taxes. I could go on and on. So we should continue to do what the statutes say until Congress gives us other instructions. Protect and promote competition.
Thank you. Diana, please.
Yeah, I'll be really interested 10 years from now to look back on this debate over competition enforcement and policy. I have to say, despite the richness of this debate and the important conversations that we are having and have had and will continue to have in events like this, there seems to be a lack of recognition that competition is and declining competition is really a public policy problem. And public policy problems require public policy approaches, which means multiple tools in the toolkit. And we got off to a start, at least in the US, where antitrust was identified as the lead dog, the tip of the spear to solve all problems, including the ones that it already solves, but also could be tasked with solving additional problems. Sort of these non-competition goals. And the debate has not really been well informed by this toolkit approach, which is how do we tap into other policy tools, IP law, labor law, consumer protection law, sector regulation. How do we tap into these other complementary tools to bootstrap and support a public policy decision and approach to promote competition in this country? And we're burning a lot of fuel on this debate. And AAI is an organization that is very action oriented, and we don't want to weaken antitrust any more than it's been weakened over the past 40 years. And we do worry that tasking antitrust to achieve things it's not designed to do will exacerbate that problem. Instead of revitalizing what it is supposed to do and strengthening and clarifying the laws to that extent.
Well, I do wonder if out of the larger discussion comes a restatement of aims, that is the abandonment of formulations that have become sterile. And along with the discussion of aims, a discussion of how one goes about doing it, both the conceptual framework of purposes and the mechanism for actually carrying them out, with an extensive discussion about how each of those aims and objectives is likely to play out in practice based on what we've done in the past. I'm grateful to all of you for participating in the discussion, to look back for a bit as a way of looking ahead at what might come in the future. I see some overlapping segments of the Venn diagrams from the conversation, and I wonder about the larger institutional issues that all of you have addressed. Some of them with more than a bit of gloom, others with more optimism, but the healthy concern not simply in concept of what we should do, but how we should go about doing it. What our system can absorb, how it functions, how it can be improved, I think is a very important ingredient of the discussion going ahead. Let me finally give a vote of thanks to those who made this format and this discussion possible. It's Fiona Schaefer in the antitrust law section of the ABA, Adam Beagle, who did so much with the organization, Svetlana Gons, just to name three, who were instrumental in putting this together, and others in the antitrust section who threw themselves into this. And yes, again, our panelists, I wanted you to join in this because you've thought about this so much. And again, so many of you have actually had to do this in practice, which is an enormous challenge as well. It certainly was a part of my greater education to go from a classroom to being a public official. And instead of watching the game, have someone say, okay, smart guy, why don't you go and play yourself? And the policy game is a difficult and challenging one. But thank you all for this. And I see this as a useful step ahead in the future discussion of what we do. So thanks again to all of you.
Thank you. Bye now.